So welcome to part 2 of the training, and for this part we'll be examining powers of attorney, healthcare proxy, living will and disposition of remains. The first document that I'll be discussing is the power of attorney, which can be very complicated to prepare, or you need to be very careful because it's very easy to make a mistake when preparing a power of attorney because there are many issues that are mentioned in the law, which is very precise, that if you are not careful when you're preparing the document can mean that something is done to the form that will convert the power of attorney document from being a statutory form into non-statutory. And if you end up with a non-statutory power of attorney, it means that the third party that should accept the power of attorney may decide not to accept it. They may choose not to accept it, and they have more scope for doing that if the power of attorney is non-statutory. So you want to, as far as you can, make sure that you prepare the document in such a way as it will conform and will remain statutory, because what you want to avoid is that the power of attorney ends up being non-statutory at a time when the client is not able to prepare a new power of attorney, and the agent will be stuck, because at that point, if the third party decides not to accept the non-statutory power of attorney, there's not much that the agent will be able to do at that point. So the key thing is stick as closely to the requirements, to the law as you can. Keep it as a statutory document, and in that way you'll have protections, or the client and the agent will have protections if a third party, for some unreasonable reason, decides that they don't want to accept it. So I'll begin by saying that the power of attorney is governed by New York General Obligations Law, Article 5, Title 15, and it has been effective since September 1st, 2009, and there were some very important amendments that took place a year later, September 2010. It's an important document because it allows one person, who's the principal under the power of attorney, to designate someone or more than one person to be their agents, and that person or people would be able to act on the principal's behalf, and that normally would take place if the principal is not able to take care of, it's usually banking matters and maybe details with their landlord to do with their housing situation. So in order for the principal to be able to designate someone, it's important that they have the power of attorney as a backup, because some people, well, definitely if you're dealing with banks, they're going to need to see some proof that the person who's coming in and saying they want to do something has authorization to do so. And many times landlords are asking for the same thing. The danger is misuse by agents. In the past there were many incidents, particularly for seniors, where some family member would get the senior to sign what used to be a very simple power of attorney form, and the grandmother or whoever it was would go into hospital and come out and find that their home had been sold during their absence, or sometimes when they were still in the home. So there were so many incidences of financial abuse of the power of attorney document that changes were made. It's made the form more complicated, but hopefully it's decreased the number of these kind of misuse that used to be quite prevalent. So the key thing to remember at the beginning is that in order to create a power of attorney and to execute a power of attorney, a key issue is going to be the capacity of the principal. And in order for the execution of a power of attorney, it requires the ability to comprehend the nature and consequences of the act of executing and granting, revoking, amending or modifying a power of attorney, any provision in a power of attorney, or the authority of any person to act as agent under a power of attorney. And complete with that statement, it should make you very aware that it's quite a high bar. So if somebody does not have the capacity to look at the power of attorney form, and if you're sitting in front of someone, to be able to explain to them what it will mean for them to sign the power of attorney, what the consequences would be, then that person, there will be some question about whether they can prepare a power of attorney. We, as far as we can during the intake process, try to make sure that the person has that level, but we will not obviously have the chance to spend as much time with the person as you will, so you should also be aware of capacity issues. The statutory short form power of attorney, I would say first of all, read the form yourself first of all, familiarise yourself with it and what all the sections are, and as I'm speaking now, it's be good for you to be looking at the form so that as I go through it you'll be able to see what I'm talking about in each part. To comply with the power of attorney law, when you're preparing the form, and the form that you'll have in your training materials does comply with this, the font size must be at least 12 point. And when it says 12 point, it doesn't say 12 point in a particular font, it just says 12 point. But as we all know, 12 point in Times New Roman and 12 point in some other font may be completely different. Because the documents that came out, the standard documents, are prepared in Times New Roman type form, at least I know that is 12 point. So I tend to just stick to that, and that way I know I'm not going to make a mistake. So I don't change the font. I keep it at 12 point Times or Times New Roman. The form needs to be signed and dated by a principal who has capacity, and it needs to be notarized. And the form has to use the exact wording for the caution to the principal and the important information for agent sections. So in the power of attorney document, that wording, as required by the law, it must be exact. There must be absolutely no changes, even if when you read the document you think that doesn't sound quite right grammatically, or I could put that same thing in a way that is clearer. Don't change a thing. Don't change the punctuation, nothing at all. I would say up front that with the power of attorney, it's not the form in which you should become creative. Stick strictly to what you see there, because it's very easy to delete something and that's it, you've made it non-statutory at the very least, if not completely invalidated, but very likely non-statutory. And on that point I will say, please do not delete whole sections of the form. With this form you do not do the usual legal thing, which is, well, if some wording or some paragraph is superfluous to what the client needs, I'll just delete it. You do not do this with the power of attorney form. There will be many sections that the client may not need. They don't want to authorize something, they're not going to use that particular paragraph or section. It stays there, because with the power of attorney form, the paragraphs or the authorizations that the client wants to provide, the client should initial those things. You don't remove anything. The client actually states what he or she wants by initialing next to that section. So don't cut anything out of the form. The other point is the agents. When somebody's choosing the agents who will be working on their behalf with the power of attorney, there is an emphasis on the duties and responsibilities and the powers of the agent. And by signing the power of attorney, the agent is acknowledging that they accept those duties and obligations. And those are fiduciary obligations on behalf of the agent. And if the client chooses to have more than one agent, then by default, if the client does not sign or initial the section that permits them to act separately, then it means that they'll be required to act together. And for some people that may be fine, it might be what they want, but for others it could be a problem. If they name their two children, for example, as agents under the power of attorney form, and one of the children lives in New York and the other child lives in Florida, that would be a problem, because if the client has not put their initial, allowing them to act separately, then if there's something that needs to be done under the power of attorney, there's going to be a delay while the Florida child either comes to New York or the documents are sent to Florida for the Florida child to sign something as well. So be aware that on the form there will be that section that has to be initialed if there's more than one agent acting. You should, when you're speaking with the client, make sure that you counsel the client to choose their agent carefully, because although there have been these changes to the power of attorney document, it's still a very strong document, and you want to make sure that the person who is named as the agent is responsible, trustworthy, somebody who will do what needs to be done on behalf of the client at a time when that's needed. So it has to be someone who's very responsible. And if there is any worry or concern, then again, this is one of the situations when you should let the client know that they can name someone to act jointly. And in that way, if you have two people, then at least one hopefully will be able to keep an eye on the other one. You have to hope that you're not having two people who are both untrustworthy, but the general hope is that you have somebody who can, if you like, monitor the other person. But what you're looking for, what the client is looking for clearly, is to have somebody who is trustworthy. The next section would be the successor agents, and again, the client can decide whether to have, for example, if they have two children, they may decide, okay, I'll have my child who lives in New York as my principal agent, and then I'll have my child who lives in Florida as the successor. And then it would only be in the case where the New York child is, for some reason, unable to serve as the power of attorney, then the Florida child, the successor, would step in that situation. If the client names more than one successor agent, then in that same section you have the option to add whether there is supposed to be any kind of order in which they would serve. So if there are two successor agents, the principal, the client, can decide, okay, well, if something happens to my first child, who is my primary agent, then I would like both of my other children who have named as successors to act together. Or the client can decide, okay, if my first choice, my primary agent, can't do this, then I want the first of my successors to step in and act on his or her own. And then if something happens to that successor, then the third one should step in. So there are options depending on what your client would prefer. The power of attorney is a durable document as it's set out right now, and which means that it becomes effective immediately that the client and the agent or agents have signed and notarized the document. And it remains in effect even in the instances where the client loses capacity. So it does not end because somebody develops dementia. And that's one of the main reasons why these documents are prepared. It's exactly for it to be in place in case somebody later on loses capacity. If some clients will say, I don't want my chosen agent to have this immediate power now. I want them to have this available in case something happens to me down the road. The two options that are most often thought of, first of all, the client does not have to give the power of attorney that they have signed and notarized to their agent immediately. They can keep it somewhere safe and just let the agent know that it's in existence and where to find it if and when needed, but they don't have to hand it over. So the agent will not have access to it until the client is ready for that to happen. That's, I think, the best way to handle that in those circumstances, because the other option is to make the power of attorney into a springing power of attorney, which means that it would not become effective until a certain event happens, like you get diagnosed with a form of dementia. The problem with that is that if the client is, for example, in hospital and the agent now needs to do something urgently on the client's behalf, there can be a delay with getting the appropriate certification from the hospital, because it requires 2 doctors to sign off. That's usually the way that it's done. Two doctors to sign off on the fact that this person has reached the stage where they do not have capacity, because of course the doctors are and the hospital facilities are aware that in doing so they are in effect authorizing, they're now allowing the power of attorney to become activated, as it were. It's coming into effect, and so they may have their own concerns about being the ones to press that button. So, and if the person decides that they want to go with that option, that change would be made in the modification section of the document. It would have to be specifically added. So I'm just basically saying this to let you know that there are 2 main options in the way that would be handled, but the best option, in my view, is to have the client sign the power of attorney and notarize the power of attorney, and then just keep it with their other documents, but letting the agent know where to find it when needed. At that point, the agent can go take the power of attorney, sign it, and have it notarized in front of a notary, and at that point it will become a valid and in effect power of attorney. There is a section next on the revocation of the power of attorney. So just to let you know that with the standard power of attorney, it does not automatically revoke previous powers of attorney. So people who have prepared powers of attorney before, if they specifically want, like for example, if they had named cousin X as the agent in that power of attorney, and now they want to name cousin Y, it would be wise to revoke in their new attorney the previous one. So that again would be written into the modification section in wording which is similar to the kind you would have in a will, just basically saying, I hereby revoke all previous powers of attorney prepared by me, or they can specifically refer to the date. They can say, I revoke the power of attorney previously prepared by me or signed by me on X date. So the next section deals with the granting of the powers, and this is the section that you should discuss very carefully with your client, because these are the authorizations that your client is going to be giving to the agent, allowing them to use. So you will see a list of A through O, and the first one deals with real estate transactions, and this one, if the person, for example, has a house, then in order to gift or transfer the property, you would not be able to do that just with the ordinary standard short form power of attorney. You would need, in addition, for the client to prepare a gifts rider on top of that, a statutory gifts rider. And I'll get onto that later on, but just to let you know that there are certain things. This is the basic short form power of attorney that we're starting with here, and it is it's deliberately limited in what an agent can do, again in response to the kind of egregious things that were going on with financial abuse of the power of attorney previously. So you can do things like, if you're the agent and this part has been initialed, you can, for example, speak to somebody's landlord if someone needs to renew their lease. You can do certain things if the person owns their property, but as I said, you cannot gift or transfer it just based on this one. You'd have the SGR as well. So many people do initial that section because they want, for our purposes, most of our clients have live-in rental property, and as I said, this does provide authorization in those circumstances, Also for the clients who live in co-ops, the person would be able to speak to the co-op board if needed and to deal with any kind of issues that come up with anything to do with their apartment that they live in as the co-op. So, and I should also point out here that as I'm going through this, you'll hear me saying initialing certain sections. This is a key thing here. In this section, when you're granting the powers, and in any of the sections on the power of attorney document, when you see any kind of brackets, it's not for a check mark. It must be initials there. If your client just uses a check mark, it means that authorization doesn't mean anything, it's invalid. It has to be their initials. So the next one is chattel and goods transactions. That's just basically if somebody, for example, needs something sold or whatever is in their life, it just means that it's almost like personal property. When you think of it in those ways, personal property transactions. Banking transactions, that's a very important one for most, if not all of our clients. It would allow the agent to go to the bank and to do things like pay the person's rent or their utilities, that sort of thing. It tends to be a very useful section, and for most of our clients it's one of the main reasons why they prepare the power of attorney. Just to let you know that the agent just using the short form power of attorney cannot change the title on somebody's bank account, or particularly a joint bank account, or change a beneficiary on a bank account unless this has been authorized under a statutory gifts rider. So it'd have to be that second section that is also in force. Under the basics, you can continue or modify, make deposits, withdrawals from any deposit account or joint account for the client's benefit, for accounts that were already in place at the time that the power of attorney was prepared. Next section is business operating transactions. Most of our clients don't have businesses, but it's there anyway. Insurance transactions, so they can, whatever, if premiums need to be paid or you have questions on behalf for one of the insurance accounts that your client or the principal has, then the agent can act under that part, but they cannot change the beneficiary or any kind of designations that are in effect on that insurance contract unless it's been authorized in the gifts rider. They can assist with estate transactions, claims and litigation, personal and family maintenance. Now again, this is a section where if, for example, the client has routinely given gifts, for example, to their children or grandchildren, and they do that each year. It could be birthday gifts, gifts for the holidays, or they've routinely given once a year a gift to a particular charity. The agent can continue to do that on the principal's behalf, but they can only make, under the short form power of attorney, they can only make a gift that totals $500 for the year. So for example, if the client would normally give $100 for a birthday to each of his or her 6 grandchildren, the agent would not be able to give $600 in 1 year in gifts in that way. If the client would like the agent to be able to continue doing that, it would require a gifts rider in addition to the basic power of attorney form. So you should discuss that with the clients and try and get a sense of what they routinely have done to this point as far as making those kind of gifts, and if they want the agent to be able to continue doing that, and particularly if it would add up to more than $500 in total for the year, then they would need a gifts rider. And I will point out, it must be gifts that are customarily made, so it's not that for the agent to decide, oh, they used to give, the principal used to give gifts to, the animal charity, but I think that it would be nice to give a gift to, a charity for wonderful looking but old and needing refurbishment cars, they could not do that. That was not customarily made by the principal, and the agent cannot institute a new gifting. So make that clear to the client when you're speaking with them. It must be something customarily done. You can continue to help with the person's benefits. The agent can continue to do that. For example, if someone receives Social Security, then under the section benefits from governmental programs or civil or military service, this would include things like Social Security, Medicare and Medicaid. So if something goes wrong with the person's Medicare and Medicaid, then if this section is initialed, then the agent would be able to apply for these kind of benefits, or change or amend, or file a claim, query something on behalf of the client. Next section, healthcare billing and payment matters. This is supposed to help with, for example, if somebody receives a medical bill, the agent would be able to query whether they've been billed for the correct amount. This section was really put in, I think, to try to help to make it HIPAA compliant, so that the health law, the privacy laws, could in the past have prevented someone from saying, I need to see the person's medical bill. This is supposed to help in that situation. If this has been initialed, so the agent can say, you see, I do have permission to check on this kind of thing. There is, however, a divide here, because having that section about healthcare billing and payment matters does not give the person the authority to actually make healthcare decisions on behalf of the client. That is in the separate document, the healthcare proxy, which I'll go on to later. So it's strictly to do with billing questions. It's in New York State, you cannot have the authorization to do these kind of financial type matters mixed in the same document as someone who is serving as an agent under a healthcare proxy, which deals with the person's medical issues, making medical decisions. So it's two separate documents in New York State. The next section is retirement and benefit transactions, tax matters, and then all other matters, and then full and unqualified authority to the agents to delegate the powers that have been given to another person. So for some people that's fine, because it's likely that the agent would maybe delegate those gifts to one of their siblings, and it might work out fine. But for some people, some of the clients, they would not want their agent to be able to hand over that kind of power to someone else, because it could be someone that the principal, that the client doesn't even know. So that's something else you should raise with your client. Option P really is useful for people who, for example, want to give a lot of these kind of authorizations, but they may have problems with writing, and this is particularly the case for someone who's had a stroke or has some difficulty with writing or putting their initials in a small space. They may be able to do it once, but they can't do it over and over again. And in this section, you can choose for clients who you feel that it's easier for them to just initial once, then you would put in whichever of the letters of the authorizations that they want to give, so anywhere from A to O, you would put that on the line next to P, and then your client only needs to initial once next to P. So whichever authorizations they would like to have, you put them in along the line of P, and they will initial just P. Otherwise, they are to initial each of the powers that they are authorizing. The next section is important. This is the modification section that I mentioned earlier, and this is the place where you can make changes to the document if necessary. So if to revoke previous powers of attorney, for example, to make it springing rather than durable, although as I said, that's not the best option. To write in anything that would be a change or to add to this form, this is where you would do that, in the modification section. The next section is important because, again, this is where, if you're going to use, or if the client needs to have a statutory gifts rider, then the client would need to initial that section, section H, which permits the gifting and transfer of property or anything that is not covered under the short form power of attorney. So this must be done at the same time. So this, when you're preparing the short form power of attorney, if there's going to be a gifts rider as well, it must be done at the same time in this same appointment. This is not something that can be done later on as an addition, otherwise it has to be, the two documents would need to be prepared at the same time at a later date. So the gift rider section would be initialed if you're going to prepare one. The client also then has the option to, if they want to designate a monitor, this is naming someone who can kind of oversee what the agents are doing and can ask for maybe once or twice a year to see the receipts, to kind of check and see what's been going on, records, documents, that sort of thing. If there's anything that should have been done by the agent and was not, or there's any thought that something is being, the power of attorney is being misused in some way, a monitor is one of the people who can bring special proceedings, special action in the court, saying, I want the court to order, for example, the agent to bring in certain documents because I think something, underhand or something is going on, and I would like the court to rule on this. So that's the designation of an agent, of a monitor. Compensation of agents. Most of our clients do not compensate their agents because it's usually just family members, but the option is there that if the principal wants the power of attorney to authorize the agent to receive money or reasonable expenses for serving as their agent, then they can do so in the power of attorney at that point. They can initial that. Third parties are supposed to accept the power of attorney unless they have a reasonable cause to refuse to accept it. And a couple of the reasons would be if the agent is asked to provide the original power of attorney, not just a copy, and they can't produce it, they should either be able to produce an original or certified copy of the power of attorney. If they're requested to do so, for example, at a bank, and they can't do that, then the bank can say that's a reasonable cause for not accepting the power of attorney. Or if the third party, for example, a bank, knows that, and this is actual knowledge, knows that there has been some kind of abuse or mistreatment, something strange going on with the agent, they've been misusing the power of attorney, then again they can refuse to accept it. But it must be actual knowledge, not them having a feeling. There must actually be a real knowledge of that. Another option would be actual knowledge or reasonable basis for believing that the principal has died, and that because if a principal dies, the power of attorney dies with them. This does not carry on beyond the death. So if, for example, the bank knows that the principal has died, they can legitimately refuse to take any more instructions from the agent under the power of attorney. And then similarly, if someone had prepared a non-durable power of attorney, then which would become void at the time when someone becomes incapacitated, if that's what is required, then if someone becomes incapacitated and it is and non-durable and that's supposed to end upon such an occurrence, then again a bank or other third party can refuse to accept it. It is unreasonable for a third party to just say, I'm not going to accept that power of attorney because we have our own power of attorney here, and that doesn't have our, logo on the top of the power of attorney. And this is something that you sometimes get because this is a statutory, it's a New York, it's to them generic, it doesn't have Bank of X on it or something, and then they're very nervous about accepting it. That is not a reasonable reason for refusing to accept the power of attorney. Similarly, if the power of attorney was executed 5 years ago, it is not a reasonable reason for refusing to accept it because, well, it's old, which I've actually heard. Someone said, it's more than a year old, you're supposed to do this every year. I mean, that was ridiculous and outrageous, and even more so because it was in a case where the client had actually, since signing the power of attorney, become incapacitated. So even if that ludicrous reason was in any way reasonable, it would have just completely defeated the whole point of the client preparing a power of attorney at that time when she was lucid and able to do so. For now, at this point, to be told, or for the agent to be told, it's more than a year old and, we don't have to accept that. There needs to be some training, I think, in some of the institutions as to how the power of attorney actually works. Another thing is there can be, and it's okay for there to be, a difference in time between when the principal, the client, signed and notarized the power of attorney and when the agent signed it. The agent and the client do not have to be in the same room at the same time signing the power, notarizing the power of attorney. It is fine for the principal to sign and notarize, put it away in a drawer, and then 3 years later, the agent, when it's now needed, signs and notarizes the power of attorney and starts using it at that point. To revoke a power of attorney, it should be done in writing, and notice of the termination states, the law states that the agent can be deemed to have received notification of a revocation. And you can do this in person, by mail, email, but they can be deemed to have received it if you've made some effort to notify them. But a third party requires actual notice of termination. So it is very important for your client to understand that if he or she wants to make changes, name someone else, do a new power of attorney, they should write to the bank or whichever institution or the landlord, whoever it is, the third party, put it in a notice, in writing, preferably do that by like a certified mail, return receipt requested, have some proof that they actually did send that in. Execution of the power of attorney requires that both the principal and the agents must sign and notarize the power of attorney before it will become effective, but as I said, that does not have to be done in the same session. The agent does not have to sign in the presence or on the same date, and there is no time limit between the signatures. A durable power of attorney will remain valid even if the client has lost capacity. If when you're doing this power of attorney with your client, if they say, I would like my daughter to be my agent, but she lives in Virginia, you should check with the client first of all, well, what do you want to do? What should I, and this is normally what would happen, but you need to instruct the client, okay, I make sure that you now have your part done. In that case, you've now prepared the power of attorney, you've initialed all the authorizations, you've initialed everything you want as to your agent to have. you've signed the document and you have, we've had this notarized. I can now give you the document and you can forward it to your daughter in Virginia and let her know that she's to sign it in front of a notary, have it notarized. That's one option. Or you can, if the client may say, no, can you do that for me? Can you send it on my behalf? You can do that, but you should make sure that you get instructions from the client, as in, my thing would be to write a letter saying, you have asked me and give me authorization to forward this to your daughter in Virginia for her to sign and have this notarized. And then, for example, then as you've indicated, you want her to then keep it, or and then you want her to send it back to you. Whatever the client says, you repeat back in the cover letter so that it's made clear that you're doing this at the client's request and you have authorization to do this action. So that's basically, when you've done that you've now completed the short form power of attorney. The next part will be the statutory gifts rider. If your client or the client's needs are such that they would require a statutory gifts rider, again, because this is the more powerful section, because this allows the client to give or allow the agent to make certain gifts that could substantially decrease the client's property, because you can do anything under the power of attorney that the client has allowed in that statutory gifts rider. So if the client says, I'm allowing you to make a gift to yourself of my house, or I'm allowing you to donate my house to the Salvation Army, that would be a substantial decrease in the client's estate. Because it's so powerful, the client has to be very clear about what it is that they are allowing to be done. So, for example, the statutory gifts rider, if you're going to make a gift to a family member, which under the short form would allow like up to $500 or something, then it means that your client is going to have to prepare the gifts rider because they want, for example, I want my daughter to be able to have $20,000, in this year. That would most definitely require a gifts rider. Equally, it might be something like, I want to be able, my agent to be able to change the designation on my insurance to go from my son to go to my, if something happens to my son, I would like my agent to be able to say, okay, in that circumstance, I'm going to change the designation on the insurance to my daughter. Without a statutory gifts rider, the agent would not be able to do something like that. The agent cannot change designations that were already put in place on an insurance policy or on a bank account without the gifts rider section. So, for example, if you look at the gifts rider, you'll see that there's a grant of limited authority to make gifts. Now, this would allow the agent to make gifts on behalf of the client to that person's spouse, children, or more remote descendants and parents, up to a certain amount. It's the amount of the annual federal gifts tax exclusion. Now, you can actually make it more than that in the modification section if that's what the principal wants. But if the principal wants to allow those gifts to their family, he or she will have to initial that section. The modification section, this is where, as I say, you can make gifts beyond, in excess of the gift tax exclusion. You can make gifts to beneficiaries that are not included in that section. They're not family members. You can make other kinds of transfers. For most of our clients, for making gifts in excess of tax, the gift tax exclusion, our clients are low income and moderate income. we're not likely to see that, but it's important that you know that that's an option there, because you will need to explain section by section what this all means to your clients. So there are many ways in which these can be modified. It depends on what your client wants to do, what they have, what their property is. You can then judge whether it can all be handled with just the basic short form, or whether you need to do this with the gifts rider. If this is specifically stated in modifications, you can say, I want the agent to be able to open a deposit account in, a new account in the client's name. I want the agent to be able to change designations and beneficiaries on various documents. I want them to be able to sell, to transfer land or a house in which the client has an interest. So there are all different things that can be added into the modification section. It depends on what your client wants, whether this will be relevant or not. Also, this is the section where you can make make amendments, so that, for example, if someone needs to be able to prepare a living trust for the client because they're thinking in terms of needing long-term health care that might require them to go on to Medicaid at some point. So it's a very broad section, and this is the area that it would have to be fitted into the modification section. Now, one key thing to point out is if the agent is someone that the client would like to be able to make transfers to him or herself, you cannot put in the modification section, I authorize my agent to be able to make gifts to him or herself. That kind of specific authority for an agent to benefit in that way comes in the next section, which is the grant of specific authority for an agent to make major gifts or other transfers to him or herself. So if your client wants, for example, if the agent is going to be a daughter, for example, an adult daughter, and your client would like that daughter to be able to make a gift, what would eventually be seen as a gift to him or herself. It might be that they jointly own a house, and the client normally would say, one will pool together and repair the roof or some other thing that needs to be done. That could be seen as a gift to the agent, because the agent could benefit from a transfer of money that's going to help to repair a roof that the agent also has an interest in. Or it could be that the client routinely would allow their daughter to take some money, just as a gift. You need a little help, so I will make a gift to you, or once a year I'll give you something. So if that agent is going to receive money or some other benefit, then it is extremely important that the client initials next to that section, allowing the agent to make gifts to him or herself. But you always have to keep in mind that even with that, the first principle is that the agent should still conform with the principle, the client's instructions, or act in the best interests of that client. So that is always going to be foremost when an agent is doing anything under the power of attorney. So if the agent is a family member and your client wants the agent to be able to make gifts to him or herself, it's important that your client initials next to A, which is the grant of limited authority to make gifts, and section C, where he or she can make gifts to him or herself. It is also very important because this section, the statutory gifts rider section, requires that it be witnessed. So unlike the first part, the short form, which only needs to be signed and notarized by the client. This section, this part, needs witnesses, and you need to make sure that whoever is going to witness the document is not someone who could otherwise benefit under the power of attorney or the gifts rider. So I'll go into that in a bit more detail in a second. So the exception and indemnification of third parties, similar to what I described for the previous section, and it must be a reasonable cause for refusal by a third party. Otherwise, if this is all done in the way that it should be done and it's a statutory form, then it should be accepted. And again, you must notify third parties in writing if you want to make sure that they don't unfortunately act under a power of attorney that you have revoked or you don't want to be continuing any longer. The signature is from the principal. Again, the principal will sign and notarize the statutory gifts rider section, and there's no requirement for the agent to sign the statutory gifts rider. Now, this is the important part about the signature of the witnesses. It must be witnessed by two disinterested witnesses, and that means two persons who are not named in the instrument, in the power of attorney, as permissible recipients of gifts or other transfers. So as I spoke earlier about the client being able to make gifts to, for example, their spouse or their children or their more remote descendants and parents, those people should not sign as witnesses on the statutory gifts rider. So even if there's no intention at this point for the principal to make gifts to those people, the fact that they could be recipients means that they should not sign as witnesses. And again, the signatures of the witnesses on the gifts rider must be notarized. So I'll just finish up by saying that there are certain pitfalls to a power of attorney, so I'll just mention them in one go again, so they'll be very clear to you that these are things you should be looking out for. If you do these things, you could potentially convert it from a statutory power of attorney into a non-statutory power of attorney. So if you try to improve on the language or the punctuation of the power of attorney as it currently is, you could end up making it non-statutory, because the law says that it must contain the exact wording of the statutory forms, although a mistake in the wording, for example spelling or punctuation or the use of bold or italics, will not prevent the forms from being treated as statutory, but it's not clear if this applies to a deliberate change. So if you do something that is a mistake, then it shouldn't make it non-statutory. However, if you change it, knowingly change it, then that is a risk. It could become non-statutory. The other way in which it may become non-statutory is if you delete unnecessary, as you may consider it to be unnecessary language. So this again, as I said, don't just delete whole chunks of the document. Any changes to the document should be made in the modifications section. Now, these are ways in which you could potentially invalidate a power of attorney. This is where the preparer corrects the cautionary language of the power of attorney. So in those situations where you see the caution to the principal and the important information for the agent sections, that language must remain absolutely as is, because the law doesn't indicate whether even a mistake in that cautionary language would be forgiven. So that needs to just stay as is. Another possible invalidation would be if you fail to use 12-point font or larger. And again, as I say, I tend to just leave it at the Times New Roman style version of 12-point font. Another one, which again is very tricky because it's easy to make this mistake, but it could have potential consequences, is that the law says that a valid power of attorney must be signed and dated by the agent. But if you look at the form in the part where it shows where the agent is going to sign, it has a signature line, but it doesn't have anything stating, date. It doesn't say date, even though the law says the agent must sign and date the form. And I think most people, when they prepare the power of attorney form, will just say, okay, to the agent, this is where you sign, and then underneath that is the section where it would be notarized. And of course, the notary would have somewhere where he or she would put the date there. That's not the same as the agent signing and dating. So to be careful, to be extra cautious, try to remember, if you are dealing with the agent, and you may not have to, because you may just be dealing with your client, and the client's part actually has the date, so that you shouldn't have any problem if you're just dealing with your client. But if you are in a situation where the agent is also there, so you will be, overseeing the signing by the agent as well as by your client, then have the agent sign and date, so they can put the date alongside the line, or even on the line next to their signature if there's room. The other thing is the date of execution, if it's typed in rather than written by hand. And again, the law says that the power of attorney must be signed and dated by a principal with capacity. So there is a line when you're dealing with your client that, where it's got the date. It's very easy and tempting, because it saves time, if you know when your client is coming in, that you may just on the form type in, with the rest of the wording, on such and such date, so it just becomes part of the typing. The safer thing to do, since this is the way it's worded in the law, is to leave it as a line that your client will insert the date on that line, rather than you typing that in advance. And finally, again, something I was just discussing a short while ago, is the potential donees serving as witnesses on the gifts rider. It must be signed by people who are not permissible recipients of gifts. Otherwise, it could potentially invalidate the gifts rider. And since there's no severance provision in the power of attorney law, in case if something's wrong with the gifts rider that's been prepared, potentially it's going to invalidate the entire thing, because the wording of the law says power of attorney and the gifts rider must be read together as a single instrument. So potentially, if one part is being invalidated, it means the whole thing is potentially invalidated. So those are the points with the power of attorney to be careful of. As I said, if you have questions, you should certainly get in touch, but just look at the form carefully, look at the power of attorney law, and it should give you a good amount of background as to what you should and should not do when preparing these documents. And with that one, I'll just finish up again by saying, when the client or the principal dies, the power of attorney form, that authorization dies with the client. You do sometimes get the agents who will go into a bank afterwards and not be aware that because the client's died, they'll just go in and say, Mr. So-and-so has died, I need to do blah, 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 and I've got a power of attorney, so I'll do it. I am the agent under the power of attorney. Instantly, the bank is going to say, that's nice, but as you've just mentioned, so-and-so has died, therefore your powers have also expired. So make that clear to the client, and for them to make it clear to the agent so that they're aware of that. Okay. So that's it for the power of attorney. I'll just go on briefly now on the other documents, which are much less complicated, easier to prepare, but I'll give you some of the background on them so that you know what you're aiming for when you're preparing these documents. I'll start with the healthcare proxy. You have all of these documents in your materials, so again you can look at this as I'm talking. The healthcare proxy is governed by Article 29 of the New York Public Health Law, and it allows adults to make decisions on behalf of someone else if they've been named as an agent under this healthcare proxy. So, as I said, unlike the power of attorney, this is the document that will be used so that someone can speak on behalf of actual medical treatments with the doctors who are assisting the client. So the benefit of this is that the client is able to choose someone who will be able to make these kind of decisions on their behalf, and it's a very broad kind of authorization. They can make decisions about any medical treatment. Now, except, and this is the exception, in New York, you have to be sure to make sure that in the in the healthcare proxy document that you have added wording which will allow the agent under the healthcare proxy to be able to make decisions about tube feeding. Without that specific authorization, the agent under the healthcare proxy will be able to make medical decisions about anything except for tube feeding. So it's artificial nutrition and hydration. So in every healthcare proxy that you prepare, you must make sure that wording to that effect is in there. It also allows the client to be able to choose a particular, for example, family member, who may be the person who lives more, closer to the client, or the person who knows them the best. It's also useful if they want to choose someone who is a non-family member, because again, in a hospital, they would be more likely to see someone or expect to see someone who is, for example, the adult child or the spouse of this person. Many of our clients don't have any family members living, in New York City or maybe even in New York State, but they have a close friend who is willing and able to act in that capacity for them, so they can name that person as their agent under the healthcare proxy. It's also helpful for the medical providers because it allows them to be clear about who they're supposed to be dealing with. If you have, for example, 4 children gathered around, dad's bedside, and all of them are saying different things about what dad would like, it's very confusing for the medical staff, and they're also very wary because they might listen to one of the children and then get sued by the other. So it provides them with guidance in a legal way as to who is the designated person that they should be listening to. There are many different types of proxy forms. They've got the New York State proxy form is what we've based ours on. In fact, we've only made one change in that we've allowed the principal, the client, to state that they do not want to make any kind of donation in terms of, whether it's organ or tissue donation. The New York State version just almost assumes that they will make one or some kind of donation. And some of our clients specifically do not want to make any kind of donation in that way. So that's all we've changed on the form that you would see as the regular form with New York State. The required elements in a healthcare proxy form is it must name the principal, and that principal must be 18 and over. It must name the agent. It must include a statement that the principal intends the agent to make healthcare decisions on their behalf. It must have the principal's signature and the date. And it must have the signature of 2 witnesses, the date, and a statement by the witnesses that the principal appeared to execute the proxy willingly. And just a reminder that neither the agent nor alternate agent who is named in the proxy, in the healthcare proxy, can serve as witnesses. There are some optional elements in the form that the client can or may choose not to fill in. It invites the client to say, this is what I do want and this is what I don't want. The best thing to do is to leave it as broad as possible. It's impossible for anyone to think of all the things that they do want to add. In the case of this, I want this. In the case of that, but on the other hand, I would want that. It's not possible to cover every eventuality or possibility. So what you're aiming at is to keep it very broad, and for the principal, for the client, to speak to the person who's going to be their agent about what they would and would not want, but don't try to put that all in the form. So all that really needs to be added in the form is, as I've said, the section where it's saying, like the instructions. In that section you would put something to the effect of, my agent, or if there's going to be more than one, agents, my agent knows my wishes regarding artificial nutrition and hydration, which is tube feeding. So that's really all you need to put in that section, because everything else, all other authorizations to do with making medical decisions, will be in effect. So all you need to do is add that tube feeding wording, and essentially what happens is that the agent then has the power to make all the decisions as things change and evolve. They can make decisions to meet those circumstances, and that is the best way to have a healthcare proxy document, so that the agent has the ability to make decisions as things arise. But a very important point is, and you must make this clear to your client, they have to make sure that their agents do know what they want. Don't just prepare a healthcare proxy form, name someone as the agent, and then when the time comes for them to make decisions, they have actually no idea what the client would want under certain circumstances, and then the agent is left to just think up for themselves, oh well, if it was me, this is what I would do. That may be completely the opposite of what the client would want, but it's the best that the agent probably can come up with under the circumstances. So even if the agent may think, well, if this was me, I would want X, if the agent knows that the client would want Y in those circumstances, the agent is supposed to say to the medical staff, I want you to do Y. Then also on the form, they can put an expiration date. Again, this is not a good idea. It's best to just leave it open, because nobody knows when this, the healthcare proxy form is going to be needed. So it's wisest just to have no expiration date. And the other section is organ and tissue donation. The client, as I said, can just say, I don't want to make that kind of donation, or some people say, yes, I want to make a donation, and they fill in the appropriate place on the form. The client needs to, when choosing an agent, needs to obviously choose someone who is trustworthy. It should not, some people say, I'd like my doctor. Usually this is someone who doesn't have family close by, and they might say, I want my doctor, I trust my doctor, I've been with him or her for years. Explain to your client that, first of all, that's something they should discuss in advance with the doctor, because the doctor may not have the time or ability to serve as their agent. But even more importantly, it needs to be made clear to the client that if they name their doctor as their agent, at the time when the healthcare proxy needs to come into effect, if the client is no longer able to make their own decisions, their doctor, who would now become the agent, is actually no longer permitted to act as their doctor. They would now become their agent, so they can speak on the client's behalf and put forward, this is what I believe she would want, this sort of thing, but they can't make medical decisions on your behalf, on the client's behalf, if they're now obligated to act as the client's agent. And for many clients, if not most clients, that's not what they would want. So I think for most people, naming the doctor as the agent is not the best thing to do. But you will sometimes have clients who will ask you about that. Another thing is they may ask you about, well, I don't really have anyone close to me, but the place where I worship, I'm very close there, and maybe I can get someone there, a priest or a rabbi, the imam, whoever it may be, whoever is the leader of their place of worship. They sometimes want to ask that person because they feel very close to them. Again, that's a discussion that should take place with that person before naming them, and also there is a limit of 10 people that someone can be an agent for, and it's possible that someone who is in that kind of position has been asked to be in that position previously, and they may already be the agent on behalf of 10 people, and they're not allowed to have more than that. So that's again something for them to be aware of. Capacity, of course, in all legal documents is an issue. This is a lower capacity than for the power of attorney, and the doctor will decide whether the client is able to make healthcare decisions by him or herself. If it comes to the point where the doctors determine that they do not have the capacity to make their own medical decisions, it's at that point that the healthcare proxy would come into effect. Just to let you know that before the agent is able to make a decision about whether a treatment should be continued, something like, I should say, life-sustaining treatment, so that the tube feeding issue, before a decision can be made to withdraw tube feeding, a second doctor must confirm that the patient's, in this case the client's, incapacity is still ongoing, and the doctors would have to put that in writing. So there is another level, but if the tube feeding authorization has been given in the healthcare proxy, then the agent can make that decision, but the medical staff, the doctors are required to again put in writing that at the time this was made, the decision to withdraw life-sustaining treatment, that the client was still incapacitated and was not able to make, to say, no, I don't want that, or I've changed my mind, or something like that. The decisions by agents should be in accordance with the principal's wishes, and that includes their religious and moral beliefs. And if the agent does not know the principal's wishes in those circumstances, then the agent must make decisions based on the principal's best interests. As I said, it's best not to put an expiration date on the healthcare proxy. If the client wants to revoke it, you should let them know that they can make some kind of action that indicates that's what they want to do. So, for example, they can tear it up, or they can put in writing across it cancelled, revoked, that sort of thing, or just by preparing a new healthcare proxy. I'll point out that if someone names their spouse as the agent in their healthcare proxy, and then they later divorce, then the healthcare proxy is automatically revoked, unless it's specifically stated in the proxy document that they would look at the principal, the client would want the agency to continue even in the event of a divorce. You should instruct your client, after they've prepared this, to give a copy to the doctor for their office records. If they're in hospital, they can give a copy to the hospital staff there. They should certainly give a copy to their agent and any alternate agent, and if it's a senior who goes to a senior centre, they sometimes give a copy. If they spend a lot of time at the centre, they may leave it with the social worker there, and the copies are valid. So unlike with the power of attorney, someone going in with a copy of the healthcare proxy is fine. that is valid. It's also valid, if you take the healthcare proxy from one facility to another, that's fine. You don't just have to have it for a particular hospital. And I'll also state that under the law, the agent's power under the healthcare proxy also expires, just like the power of attorney expires upon the death of the client or the principal. So I'll talk briefly about the living will, which is a document that you'll often see prepared alongside the healthcare proxy. It doesn't have its own specific law. It's actually, it's kind of evolved in New York State. Some states have it as a specific law. New Jersey is different from us. They have a particular law. In New York, it counts as persuasive evidence of the client's wishes. So it has kind of evolved through case law. If the client's wish is to be kept alive, some clients will say, I don't want to, if I'm in a very bad way and they think I'm not going to survive, whatever state I'm in, I want the doctors to do whatever is necessary, put me on every machine, keep me going. If that is the client's wish, then you do not prepare a living will. A living will is more of an end-of-life document that deals with the person saying, if I get to the point where I'm not going, likely to recover, I'm in a persistent vegetative state, something like this. The prognosis is not good. In those circumstances, I would say to the medical staff, do not, use what generally was termed extraordinary measures. I don't want you fighting to keep me going if, for example, I'm brain dead. So if I'm in a persistent vegetative state or I'm in a coma, there's no sign that I'm going to come out, and then I have, my heart stops beating or my breathing stops, I don't want you putting me on breathing tubes or, opening my chest up to do cardiac massage. I don't want you doing those kinds of things. If there's no chance I'm going to recover anyway, don't do those kind of things. So that is what the living will is aimed at. So if your client is saying, I want the doctors to do everything, then this is not an appropriate document for that client. So most clients will have thoughts about if they do want to have this kind of end-of-life document, just take a look at the form and you will see the kind of situations that it's saying that if this happens to me, I don't want you to do these medical interventions. It just says I want to be kept pain-free. In the other instructions part of the form, you can write in there, my agent is to be guided by my wishes as expressed in this document. So if somebody has a healthcare proxy in place and you want to tie the two documents together, then you can do it by writing in that wording, and you can even say my agent under my healthcare proxy dated such and such is to be guided by my wishes as expressed in this document. You could also put something like, any questions on the interpretation or application of my living will are to be decided by my agent under my healthcare proxy. Something like that. So just letting the doctors know that if this is the case, that this is the client's wish, that after a certain point they do not want any kind of intervention treatment. The principal then signs and addresses and dates the form, and then the witnesses sign and print their names on the form and add their address. And I do say print because the form that I'm thinking of, the one that we use here, which you'll see in your materials, sometimes people just sign their name, but you can't read the signature. So we usually will say, sign your name and then print the name next to the signature, and then the witnesses add their addresses after that. And again, with the living will, it would expire upon the death of the client. For some people, this is a form that is an option when they don't have anyone that they can name as to be an agent under the healthcare proxy. And so sometimes all they can do is look, the doctors are going to be making all the decisions for me because I don't have an agent, but if I get to the stage where I am not going to recover, then I want the doctors to stop. So they'll just prepare, the living will, and they'll give that to their doctors and say, this is where, for me, the stopping point is. Another option that you should know if any of your clients are in that situation, if they don't have anyone they can name to be their agent in a healthcare proxy, is that there is something that is called a MOLST. It's MOLST. It stands for Medical Orders for Life-Sustaining Treatment. And this is something that they should speak to the doctors about. It's a bright pink form, and it allows them to, in advance, say to their doctors, these are the kind of treatments that I want in these conditions. So it's like having an agent, as you would have under a healthcare proxy, but it's directed specifically at the doctors, at the medical staff. So if any of your clients tell you that they can't prepare a healthcare proxy because they have no one who can serve as an agent, and we do have clients who are in that position, let them know that they should speak to their doctors about getting a MOLST, M-O-L-S-T form, having that conversation, and then the doctor can have that in place. Finally, the last document is an appointment to control the disposition of remains. And it's similar in form to a healthcare proxy, but instead of the agent making healthcare decisions, the agent makes funeral and burial decisions. And if you look at the form again, it's in your materials, all you'll see, as I said, similar to healthcare proxy, you will insert the client's name, the address, the name and address of the agent. So your client will have, for example, John Smith, hereby appoint, Bill Brown, and you put the contact details of the agent who is going to be making these decisions for your client. The special directions section is where your client would give any information. For example, some people have funeral plots, family plots, or they may have purchased a plot in a cemetery. It may be that they want to say they would like to be cremated. So anyone who has any special requirements that they're going to want, or they've put something in place, they would put it in the special directions section. And it's important that, if example, for cremation, because some funeral homes are very wary about cremations because they have been sued in the past where somebody, even a family member, has come in and said, oh yes, we want you to cremate this person. And then another family member has come in and said, why have you cremated my mother? She would never have wanted to be cremated, and then it ends up in a lawsuit. So funeral homes can be very worried about some of the aspects of funeral and burial arrangements. So if somebody wants something that is in any way specific, it should be put in there, and particularly if someone intends to be cremated. The next section deals with prepaid funeral plans. Some people have put those in place. This is the section in which you should indicate whether or not the client has put that plan in place. Then on the next page you have the details of the agents. You put all their contact details there. You have a revocation clause, which will be, so you're revoking all previous disposition of remains forms that you may have prepared in the past. There's then a witness statement that is going to be signed and witnessed by 2 people, neither of whom must be agents named in the form. And then the last part I'll point out is the acceptance and assumption by agent. That last section of the form should only be completed after the client's death. So you should make sure that the client understands that at the time when you're signing all the forms, everything is being signed and witnessed, that the last section, acceptance and assumption by agent, is to be completed at the time when the form is now going to be used. So at the client's death, the agent now has the form, should sign and date the form, because essentially what he or she is saying at that point is that they know of no form that has been created since this one was dated by the client, and so that the agent who's been named is still the right person, is still the person who is authorized to make those arrangements. So that is something that should only be signed by the agent right at the time when they're going to start using the document. And unlike the other documents, this one comes into effect when the client dies and once the agent has signed and accepted the appointment. At that point, this document is now when it should be used. It becomes effective. So that concludes the advanced directives. So in part 2, you've had the power of attorney, the healthcare proxy, living will, and disposition of remains. As I said, the healthcare proxy, living will, and disposition of remains forms are all relatively simple to prepare. They're quite clear. Have a look at them, read through them, make yourself familiar with all the points, and you should be able to guide the clients through them relatively simple, in a very simple way. The power of attorney, as I said, that definitely merits some time on your part, just reading through it and looking at the law itself and making yourself familiar with the laws behind the actual form. But if you're not aware of them, as I said, you can make mistakes that can end up with quite severe consequences for the agent who's trying to act on behalf of the client. So as a final word, I will say, when you're preparing a will, make sure that you complete the will, a witness affidavit, and a family tree affidavit. You may, depending on your client, need to prepare amended or additional documents, as compared to just the standard versions, if there's something about your client's case that merits it. So for example, if your client is non-English speaking, then the witness affidavit for the will would have to be the one, and again you have this in your materials, that specifies that the document was interpreted, translated into the client's language. So that's the kind of change. We also sometimes have clients who have various disabilities. For example, it could be someone who has a physical or visual impairment, and again we have documents that we can provide to you that are specially tailored for those situations that you can then amend to accurately reflect your own client's situation. For clients, we sometimes have clients who ask us to prepare documents and they're a married couple. So sometimes you may accept a case and it's for a married couple. In that case, we have a special consent form, which is for spouses who are being represented by the same attorney. And for a power of attorney, again, just make sure that if you make any substantial changes to the power of attorney form, it might be an idea to just read over it carefully, think of all the warnings I've given you in this training, and if you have any questions, feel free to get in touch with me. And make sure that your client is using initials on the power of attorney form and not making check marks. And just on a general note, feel free always, if you have any questions about anything, stay in touch with the staff here on the project. We're happy to help you with any questions that you have. I'm happy to look at any draft documents that you're preparing. If along the way you're unable for some reason to contact the client, please let us know. After this, I'll just say if you can make sure to complete and return to us the volunteer information form, we'll enter your details into the database and we'll send you a confirmation that you've been added so that you'll start receive notifications of cases. And just to say that I hope you'll enjoy working on the project. So thank you for participating. I look forward to working with you.